examiners frequently receive replies to office actions that include citations of case law. Yet most examiners are not attorneys. They may be unfamiliar with the impact of case law on their job as patent examiners. This CBT is part 1 of a 2-part examiner training course. Part 1 is designed to familiarize you with the federal court system and the kinds of case law that are relevant to the patentability determinations that you make every day. Part 2 is an interactive workshop-style session that will provide practical strategies for writing a clear response to attorney arguments that are based on case law. This training is intended to be a review or refresher of your understanding of case law and the federal court system. The training objectives slide and the one that follows talk about what you can expect from this CBT. This CBT is intended to achieve 3 objectives. First, you should gain a better understanding of the legal authority for patents in the United States. Second, you will become familiar with how the patentability decisions you make are reviewed. The review process will differ somewhat depending on whether you have rejected or allowed the claims. Finally, you will recognize that the MPEP is an important resource and should be your first stop when faced with responding to an attorney argument that involves case law. We also want to be clear about what this CBT is not intended to do. First, you are not being asked to do legal research other than to review the MPEP and other USPTO resources for guidance about case law. Second, although this CBT provides an overview of the federal court system and case law as it relates to the patent examiner's job, it is not intended to be a comprehensive treatment of this far-ranging topic. Finally, this Part 1 training is about understanding case law and the federal courts. In the follow-up Part 2 training, we will discuss how examiners should respond to attorney arguments. Although the cases cited and the examples discussed will necessarily involve specific statutes, neither Part 1 nor Part 2 is designed to train examiners how to write rejections under any particular section of the statute. Furthermore, this training will not address technical questions that are specific to particular art areas. To accomplish the objectives for this training, we'll consider these topics: patents and the U.S. legal system, legal review of patents, case law citations and how to retrieve cases. By way of conclusion, we'll provide some takeaway messages for examiners. We'll begin now with our first topic, patents and the U.S. legal system. The Constitution itself gives Congress the authority to create both a copyright system and a patent system in Article 1, Section 8, Clause 8. Congress has the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Note the parallel structure employed by the drafter of this constitutional provision. Science, authors, and writings refer to the copyright system. Useful arts, inventors, and discoveries refer to the patent system. All 3 branches of government established by the Constitution have an impact on patent law. As the legislative branch, Congress passes the laws that govern the patent system. The USPTO, as part of the executive branch, implements the patent laws passed by Congress. The federal courts of the judicial branch review the laws passed by Congress and the regulations promulgated by the USPTO to implement the laws, and can also resolve disputes between parties. This CBT focuses on the federal court system because all patent law in the United States is federal law. Individual states do not have their own patent laws. Any legal action involving patent rights must be brought in federal court, not state court. Federal courts include the Supreme Court, the appellate courts, and the district courts. There are 11 regional circuit courts of appeal that serve distinct geographical areas of the United States. 2 other appellate courts, the Court of Appeals for the District of Columbia Circuit and the Court of Appeals for the Federal Circuit, have nationwide jurisdiction as to certain subject matter. Finally, there are 94 federal district courts, which also serve particular geographic areas. Aside from the Supreme Court, the Court of Appeals for the Federal Circuit is the most important court for patent law. You'll often hear this court referred to as the Federal Circuit, or even FedSur, or CAFC. The Federal Circuit has existed since 1982. It is a court of nationwide jurisdiction for appeals that arise under the patent laws. The Federal Circuit can hear appeals from decisions of the USPTO, such as Patent Trial and Appeal Board or PTAB decisions affirming an examiner's rejection. It can also hear appeals from district court decisions, such as those involving patent infringement. The Court of Customs and Patent Appeals, or CCPA, no longer exists, but its cases are still important because before 1982, it had exclusive jurisdiction over appeals from USPTO decisions. In this way, the CCPA was like the Federal Circuit. However, unlike the Federal Circuit, the CCPA did not hear appeals of infringement or other district court decisions. Instead, those appeals went to one of the 11 regional circuit courts of appeals. We'll move now to our second topic, legal review of patents. This slide provides a schematic showing how a patent application that is twice rejected by the examiner can be reviewed by the PTAB and the federal courts. It's important because it shows the pathway that leads to the courts that decide the cases that influence how examiners do their job. The flowchart begins with the patent application in the red box. You are familiar with review of a patent examiner's rejection on appeal to the PTAB. If the PTAB affirms the examiner's decision, then there are 2 choices. The first option is that the PTAB's decision can be appealed directly to the Federal Circuit. The second option is that a civil action can be brought in district court. That civil action can then be followed by an appeal to the Federal Circuit. A party who is unsatisfied with the Federal Circuit's decision may ask the Supreme Court to hear the case by filing a petition for certiorari. Note that the patent examiner's decision may be only 3 steps away from the Supreme Court. This slide is similar to the previous slide, but it involves review of issued patents. Here, the flowchart begins with the issued patent in the red box. You'll note that the review pathways for issued patents are somewhat more complex than those for rejected applications. However, you can focus on the big picture. Since the passage of the AIA, an issued patent can be reviewed under one of the PTAB trial procedures that we mentioned earlier. Alternatively, a patent can be the subject of an action in district court. For example, a patentee can enforce his or her rights against an infringer. Both PTAB and district court decisions can be appealed to the Federal Circuit. Federal Circuit decisions can be the subject of a petition for certiorari that requests Supreme Court review of the Federal Circuit's decision. Patent matters brought before the PTAB or a federal court must be decided in accordance with the applicable laws and regulations. The Constitution is the most authoritative legal document. Below the Constitution in the hierarchy of legal authority are the federal statutes. Finally, federal regulations promulgated by agencies to implement the statutes are at the bottom of the pyramid. Both federal statutes and federal regulations may be challenged in court. We have seen that there is a hierarchy of legal authority that must be followed when deciding questions of patent law. There is also a hierarchy of courts. The Supreme Court is at the top of the pyramid. Next come the Circuit Courts of Appeals. The slide shows the Federal Circuit because, as we have already noted, the Federal Circuit hears all appeals that concern patent matters. The district courts come at the bottom of the pyramid below the Federal Circuit. You have probably heard the term precedential with regard to certain court decisions. Case law is called precedential when its holding must be followed in other cases that involve similar issues or facts. Supreme Court decisions are always precedential, and lower tribunals, including the Federal Circuit, the district courts, and the PTAB, must follow them. Appeals at the Federal Circuit are usually decided by a panel of 3 judges. However, sometimes all of the judges on the court sit together to decide a case. This is called an en banc decision. A 3-judge panel must treat a decision of an earlier 3-judge panel as precedential and may not overrule it. The Federal Circuit must sit en banc in order to overrule a panel decision. Thus, if a later Federal Circuit panel decision were to conflict with an earlier one, the earlier decision would control. Finally, when the Federal Circuit sits en banc, it can overrule its own earlier en banc decisions. The important point to remember is that it always takes an en banc decision to overrule any earlier decision. The Federal Circuit has chosen to adopt CCPA decisions as precedent that must be followed. Thus, CCPA decisions are precedential and may be cited unless they have been overruled. Unlike the Federal Circuit, the CCPA sat en banc for all of its decisions. That means that later CCPA decisions are effective to overrule earlier CCPA decisions. We noted on the previous slide that the en banc Federal Circuit can overrule its own prior en banc decisions. Similarly, the en banc Federal Circuit can overrule decisions of the CCPA. Decisions cited by attorneys in their replies to office actions most often come from the Supreme Court or the Federal Circuit. Because only precedential decisions must be followed in later cases, it is not common for attorneys to cite non-precedential court decisions. For example, district court decisions are not controlling precedent as to any other case, so they are not often cited in attorney replies to office actions. Sometimes attorneys cite PTAB decisions in response to office actions. PTAB decisions can be important for their persuasive value if the facts and legal issues are similar to those in your case. However, they do not have the precedential authority of Supreme Court or Federal Circuit decisions. You can learn a lot about a legal decision just from its name. A patent case called Ex Parte Applicant was decided by the PTAB or an earlier USPTO board. If a patent case is called In Re Applicant, it was decided by the Federal Circuit on appeal from a decision of the PTAB. Some cases name 2 parties. If one of them is a current or former USPTO director, either applicant versus director of USPTO or director of USPTO versus applicant, then the case is either a Federal Circuit decision arising from a suit against the USPTO in district court, or a Supreme Court decision following an in re applicant decision from the Federal Circuit. Finally, a 2-party case name in which neither is the director of the USPTO arises from a suit between 2 private parties. For example, it may be an infringement action brought in district court or a PTAB trial proceeding. A Party A versus Party B case may be decided by the PTAB, the Federal Circuit, or the Supreme Court. This slide provides some examples of case names. Ex parte Quist was a case decided by the Board of Patent Appeals and Interferences, which was the predecessor of the PTAB. In re Cuban was a Federal Circuit decision on appeal from an ex parte decision of the Board. In Bilski versus Kapos, the Supreme Court rendered a decision reviewing the Federal Circuit's decision in re Bilski. David Kapos was the director of the USPTO at the time. The well-known KSR versus Teleflex decision is a Supreme Court case on review of a Federal Circuit decision. Teleflex had sued KSR for infringement in district court. Some issues decided by the Federal Circuit are questions of law, while others are questions of fact. For example, subject matter eligibility, double patenting, indefiniteness, and claim construction are questions of law. Utility, anticipation, and written description are questions of fact. Sometimes the Federal Circuit must decide questions that involve both legal and factual aspects. These are sometimes called mixed questions of law and fact, and include obviousness, enablement, and entitlement to benefit of an earlier filed application. When making decisions, the Federal Circuit must follow particular standards that depend on whether the question is one of law or one of fact. The Federal Circuit does not give deference to PTAB or district court decisions that involve questions of law. Instead, the Federal Circuit decides such issues for itself. This is called rendering a decision de novo. On the other hand, the Federal Circuit is required to give deference to questions of fact that were decided by the PTAB or the district court. If the factual question was decided by the district court, the Federal Circuit accords some deference according to the clearly erroneous standard. Unless the Federal Circuit believes that the district court's factual decision was clearly erroneous, the Federal Circuit must defer to the district court's decision. If the factual question was decided by the PTAB, the Federal Circuit is required to give even more deference, and the decision is reviewed under the substantial evidence standard. Substantial evidence means that a reasonable person can accept the evidence as adequate to support the factual finding. The Federal Circuit must defer to the PTAB's factual decision as long as it is supported by substantial evidence. It can be important for examiners to understand how the Federal Circuit reviews questions of law and questions of fact. For example, deciding what the prior art teaches is a factual determination that is important when considering anticipation and obviousness. Because PTAB judges must support their factual findings with substantial evidence in order to receive deference from the Federal Circuit, examiners who provide a clear explanation of the bases for their rejections in the prior art are more likely to have their rejections affirmed by the PTAB. Patent examiners should rely on the guidance found in the MPEP and any supplemental examiner guidance documents. The USPTO's examination guidance is drafted carefully and reviewed thoroughly to ensure that it is consistent with the laws, regulations, and judicial decisions that are relevant to patent examination. One function of the MPEP is to explain important case law that patent examiners may encounter. Look to the MPEP and any additional guidance for USPTO policy concerning how particular cases should be applied during examination. Some cases apply across a variety of technologies, while others may be limited to particular factual situations. Examiners can determine whether a particular piece of case law is discussed in the MPEP by consulting Appendix 2. Appendix 2 of the MPEP is called List of Decisions Cited and is an alphabetical listing of all cases mentioned in the MPEP. The electronic version of the MPEP includes hyperlinks so that you can easily access the MPEP sections that are relevant to a particular case directly from Appendix 2. Executing a keyword search, for example, Alice /5 CLS, in the eMPEP will return hits in both the list of decisions cited and the section where the case is discussed. On occasion, attorneys will respond to a rejection by arguing that the MPEP is not the law or that there is an error in the MPEP. It is absolutely correct that the MPEP does not carry the same authority as statutes or regulations. Nevertheless, examiners are expected to follow the guidance provided in the MPEP and other USPTO guidance documents. If you have a question about the MPEP or other guidance in view of case law cited by an attorney, consult your SPE or practice specialist. We'll move now to our third topic, case law citations and how to retrieve cases. Attorneys usually use a standard format for citing case law. A common practice is to cite a federal case law reporter published by West. The volume number, reporter name, and the page number where the decision begins are provided. Sometimes the page number of the relevant information, called a pinpoint cite, is indicated. It is also common to see citations to the United States Patent Quarterly, USPQ, or to both the West Reporter and the USPQ. Here is an example of a citation of a quote from KSR versus Teleflex, which was a Supreme Court decision. The first part of the citation is the case name, and it is usually underlined or italicized. Next comes an indication of where the case can be found. 550 is the volume number. US is the abbreviation for the name of the West Reporter where the decision was published. The West Reporter for Supreme Court decisions is called United States. 398 is the page number where the decision begins, and 421 is the page number where the particular quoted passage may be found. This example includes a parallel citation to another reporter. In other words, more than one publisher has published this decision, and you can look at either publication to read the case. Once again, the first number, 82, represents the volume. USPQ2D is the abbreviated name of the reporter, which is United States Patent Quarterly, Second Series. The first page of the decision, 1385, and the page where the quote may be found, 1397, are also indicated. Finally, the year of the decision is indicated in parentheses. This is an example of a citation of a quote from a Federal Circuit decision. Again, it begins with the name of the case, which is usually either underlined or italicized. Next comes the West Reporter citation, including the volume number, the abbreviated name of the reporter, the first page of the decision, and the specific page where the quote is located. Finally, in parentheses, comes the name of the court and the year. You may recall that on the previous slide, the citation to a Supreme Court decision did not indicate the deciding court along with the year. That is because the abbreviated reporter name US for Supreme Court decisions conveys the deciding court, so it is unnecessary to provide that information again. Patent examiners have desktop access to court decisions related to patent law. Bloomberg BNA, which is the publisher of the United States Patent Quarterly, maintains an online search page for its Bloomberg BNA Intellectual Property Law Resource Center. The easiest way to access the search page is through the Patent Examiner's Toolkit but other ways to reach the page are also indicated on this slide. Here's a screenshot of the Bloomberg BNA Intellectual Property Law Resource Center search page. If you know either the West citation or the USPQ citation for a case, you can enter it in the search box and click Go to retrieve the case. There are also other ways to search for case law using this search page. Consult an ITERP if you need more information. The next few slides use KSR versus Teleflex as an example to familiarize you with the documents you can retrieve through the Bloomberg BNA Intellectual Property Law Resource Center search page. Here's an example from the top of the first page of the KSR decision. You'll see the case name, the deciding court, the case number, and the date of the decision by the court. In this example, there are also several parallel citations that indicate some of the various reporters that have published this decision. Following the heading information will be several headnotes. These are added by the particular publisher whose publication of the case you are reading. They are intended as a value-added feature to summarize the legal issues discussed in the case. Clicking on a headnote number will allow you to skip directly to the place in the decision where that topic is discussed. The other clickable feature is a topical code that the publisher uses as an indexing aid for a particular topic. These codes may be used to locate other decisions which discuss the same topic. For more information, consult an ITERP. Several other sections follow the headnotes but precede the actual decision of the court. These include sections about the patents involved in the case, the history and disposition of the case, and the names of the attorneys involved. The final section before the actual decision is the syllabus, which is commonly included for Supreme Court decisions, but generally not seen for decisions of lower courts. It is a summary of the case, but does not form an actual part of the decision of the court. The important point to know is that none of these preliminary items constitutes the decision of the court. Thus, they should not be cited. The slide shows the beginning of the actual opinion of the court in the KSR decision. The page number is indicated. Note that this is the page number in the USPQ publication of the decision and not the page number in the West Reporter. There is an indication of whether or not the opinion was unanimous. You will be able to tell where the opinion itself starts because it follows the words opinion text and opinion by and the name of the authoring justice or judge. Sometimes more than one judge offers an opinion on a particular case. The decision in KSR was by a unanimous court, but the court may be divided. Additional opinions may include dissents, concurrences, and concurrences in the judgment. It is important to recognize that such opinions are those of the particular judges who write them and are not the decision of the court. They are not precedential, even if they are written by Supreme Court or Federal Circuit judges. Here is an example of a Supreme Court case in which the court was divided. In Bilski v. Kapos, there were two concurring opinions in addition to the opinion of the court. Furthermore, the main opinion authored by Justice Kennedy was divided into sections, and not all justices agreed with every section. It can sometimes be difficult to determine which sections of a decision are precedential. When in doubt, consult the MPEP or ask your SPE or practice specialist for help. We'll move now to our fourth topic, takeaway messages for examiners. The MPEP, together with other USPTO guidance documents, provides an important resource for examiners. You should refer to those materials for explanations of case law. As an examiner, you are not expected to do additional legal research. There is no expectation that you will cite case law every time you write a rejection. Case law can be important, though, especially when your application involves legal and factual issues that are similar to those that were at issue in the case. In such situations, it is appropriate to cite case law. If you do choose to cite case law, do so cautiously. Merely citing case law is not a substitute for providing an adequate explanation of a rejection. In order to respond appropriately to attorney arguments based on case law, it is helpful to understand the role of the courts and the precedential value of case law. Case law can sometimes be helpful when an examiner must decide whether to make or maintain a rejection. Look to the MPEP and other USPTO guidance materials for explanations of how important cases should be applied during examination. The main purpose of this CBT has been to provide an overview of how to recognize and retrieve relevant case law. In an upcoming workshop, you will receive training on how to respond when attorneys present arguments based on case law. Participation in the workshop training will be mandatory for all GS 12 to 15 examiners, SPEs, MQASs, and TQASs.